rapid-fire trigger activators in Maryland. Are they legal?
Listen up.
I'm Duane Urban, and welcome to the Urban Defense Podcast, featuring discussion on firearms, concealed carry, self-defense, the law, and much more. Designed to inform, educate, and increase your survival in a critical incident, with your hosts, Duane Urban and Andrew Saller. Welcome to the Urban Defense Podcast, and today we're going to be talking about a topic we get asked a lot of questions about. Andrew.
Rapid fire trigger activators.
That sounds very scary.
If you're a member of the Maryland legislature, the scariest. The legislature, in their infinite wisdom, has last year passed a law, once again, restricting the rapid fire trigger activators, as well as a number of other commonly held items in the Second Amendment community. In all likelihood, they are probably illegal. For those of you who have been following the news lately, we've even seen the mayor and city council of Baltimore have decided it is a good idea to sue Glock because their firearms are susceptible to modification by these rapid fire trigger activators. Now, any sensible person would say, what is a rapid fire trigger activator? And let's turn to Duane with a legal definition.
All right. Well, so passed into law 2024 in the legislative session is 4305.1 of the Maryland criminal law article. Yes.
Of the criminal law article of the Maryland Annotated Code.
Ah, very good. Well, at any rate, this is what it says. Except as provided in subsection B of this section, a person may not transport a rapid fire activator into the state or manufacture, possess, sell, offer to sell, transfer, purchase, or receive a rapid fire activator.
So, ladies and gentlemen, commonly we're asked about magazines. And if you compare the text of the magazine ban to the text of this, you will see this is much more expansive. The legislature has gone out of their way to make sure there are no loopholes that I can see.
So they were, though, kind enough to say that this section does not apply to the possession of a rapid fire activator by a person who, number one, possessed the rapid fire activator before October 1st of 2018. Two, applied to the Federal Bureau of Alcohol, Tobacco, Firearms, and Explosives before October 1st of 2018 for authorization to possess a rapid fire activator. Three, received authorization to possess a rapid fire activator from the Federal Bureau of Alcohol, Tobacco, Firearms, and Explosives.
Not a thing.
No. There's a problem with that, and we're going to talk about what that problem is in a minute.
The Bureau of Alcohol, Tobacco, Firearms, and Explosives, that is very much a thing. But them approving rapid fire trigger activators is not a thing. And Duane's going to get into that a little bit further on.
Yeah, and there are two other things that are exceptions. One says nothing in this section is intended to prohibit the otherwise lawful possession of a part or combination of parts by a police officer or other person employed by a law enforcement agency under circumstances in which the officer or other person possesses the part or parts in accordance with authorization given by the law enforcement agency, or, number two, a person who has registered a machine gun with the Secretary of State Police under 4-403 of this title, if the part or parts are possessed for use in only and necessary for the proper function of a machine gun that is currently registered by that person under 4-403 of this title. So would not affect your H&K Sears, NFA items like that. So you may ask then, what is the definition of some of these things? Because that's been the question, is some people say, well, I know that some of these things are banned, but I don't think this particular one is banned or that particular one is banned, and there's some confusion. So let's go ahead and shed some light on that confusion.
The goal being, if I'm the legislature, to ban them all.
Well, we're getting to that. So
as quickly as we can.
If we get into section 4-301 definitions, I'm going to read a few definitions. So the first one, and this comes out of the quote-unquote assault weapon legislation. And the first one we're going to look at, the first definition we're going to look at is binary trigger system, which under this section means a device that when installed in or attached to a firearm fires both when the trigger is pulled on release of on release of the trigger. The next thing we're going to look at is bump stocks, which is defined in this section as a device that when installed in or attached to a firearm increases the rate of fire of the firearm by using energy from the recoil of the firearm to generate a reciprocating action that facilitates repeated activation of the trigger.
Everyone remembers bump stocks from the unfortunate shooting in Las Vegas. They were banned by the Bureau of Alcohol, Tobacco, Firearms, and Explosives for a while. That ban was later rescinded. Don't get confused because that was on a federal level, not here in our great state of Maryland.
The next definition we're going to look at is going to be burst trigger system, which is defined as a device that when installed in or attached to a firearm allows the firearm to discharge 2 or more shots with a single pull of the trigger by altering the trigger reset. I'm going to skip over this one because we're going to come back to it, and we are going to go to the last one, which is going to be, well, there's 2 more. Actually, switch or auto sear, meaning a device that applies force to a firearm's trigger bar to prevent it from limiting the weapon to firing only 1 round each time the trigger is depressed. And the final definition is going to be trigger crank, which is a device that when installed in or attached to a firearm repeatedly activates the trigger of the firearm through the use of a crank, a lever, or any other part that is turned in a circular motion. So, going back a page, now let us define those rapid fire activators that are banned. In this section, a rapid fire activator means any device, including a removable, manual, or power-driven activating device, constructed so that when installed or attached to a firearm, the rate at which the trigger is activated increases, or the rate of fire increases. Further defined, rapid fire activator includes a bump stock, trigger crank, Hellfire trigger, binary trigger system, burst trigger system, switch auto sear, or a copy or similar device, regardless of the producer or manufacturer. It does not, however, include a semi-automatic replacement trigger that improves the performance and functionality over the stock trigger, effectively banning all of those items. But wait, it said that you could have asked for approval to the ATF via letter and then would have had to have received that approval. So for those of you that remember, many people sent letters to the ATF requesting approval. And the ATF sent, for many of these people, a response back. I'm not going to read the entire thing, but here's the meat and potatoes. The item listed in your question is not regulated by ATF. Your question appears to be related to a recently signed statute that restricts possession in Maryland of rapid fire trigger activators, defined as any device, including a bump stock that increases a firearm's rate of fire or the rate at which a trigger is activated. The statute specifically prohibits any person from transporting a rapid fire trigger activator into Maryland or manufacturing, possessing, selling, offering to sell, transferring, purchasing, or receiving a rapid fire trigger activator in the state. This statute also contains a provision that purports to allow Maryland residents already in possession of a device covered by the law to continue to possess that device in Maryland if they file an application for, quote, authorization to possess the device with the Bureau of Alcohol, Tobacco, Firearms, and Explosives before October 1st, 2018. It goes into some more discussion, and at the end it says, ATF regrets any confusion and inconvenience caused by the provisions of the Maryland statute that mistakenly indicate ATF has the authority to approve possession of devices covered by this statute. Regards, from the ATF.
So the point being, I will take your case if you want to be a test case, one of our viewers out there. But
pro bono?
Yeah, I don't know about that now.
How else would he afford these fine suits that he always wears?
Yeah.
$30 a month like Benson.
They're not free.
This season, I have my initials on my shirt in case I forget who I am.
As that said, the rental company knows who to give it to.
So looking at all this, if you're in substantial compliance, you might, maybe be able to make a colorable argument under the law. But to the vast majority of our viewers, possessing any of these devices will be unpleasant.
So your assertion is that because they've written it the way they did, there is no way to actually comply with it.
You would have to have done everything required under the statute, and we could try and make a substantial compliance argument. But once again, that's only going to apply to people that prior to 2018 bothered to send letters off, got responses, have proof of the responses, still have the device, can show they purchased it before 2018. It will be a mess.
So for our viewers out there that, in fact, have these devices, they're all of them contraband. Andrew?
Unequivocally.
All right. So for the Urban Defense Podcast, remember to comment, like, share, and subscribe. And remember, knowledge is mental ammunition, and train, fight, and win.